It's unfortunate that we have to go through a thing like that. I consider it to be more election interference by the Democrats.
It's just so outrageous that Trump continues to think that he is above the law, above the Constitution, and above the court system.
This 345-page report by the special counsel stops short of recommending criminal charges, but it is harshly critical of the then Vice President.
Hello, everyone. I'm Major Garrett in Washington. Welcome to a special hour-long edition of America Decides. We will, I promise, get to special counsel Robert Hur's decision not to charge President Biden for careless and quote-unquote willful mishandling of classified documents while vice president and senator. As we do so, we will also examine Hur's shocking observations about Mr. Biden's memory lapses, including failing to remember during their interview the year his son, Beau, died. We will get to that and much more. But first, the Supreme Court is not a trial court. It is not, as the saying goes, a finder of fact. Another way of thinking about that is the Supreme Court does not ask, how did we get here? It does ask what the Constitution says, what a law means, or what the lawmakers who wrote a specific law intended. But it does not ask, how did we get here? Today, the Supreme Court heard case 20719, Donald Trump versus Norma Anderson. Norma is a Colorado voter, a Republican who believed Trump should be removed from the primary ballot in Colorado because he engaged in an insurrection, in violation, according to her reading, of Section 3 of the 14th Amendment. What was the basis of Anderson's claim, later validated by the Colorado Supreme Court? The basis was that Trump, ignoring his own campaign lawyers and attorney general, lied repeatedly about the 2020 election. Further, Trump did nothing while a riot led by his supporters on Capitol Hill sought to delay the peaceful transfer of power on January 6, 2021. Now, was that an insurrection? The Supreme Court wasn't really interested in that question. It was interested in other matters. But of course, that is the why beneath everything. It took more than 2 hours of dramatic Supreme Court oral arguments to ponder a question never before asked in our country's history. Can a state, should a state, remove a former president's name from a ballot because that president rebelled against the nation and its form of government? That's why the court focused on the other question, what to do about it, not so much how we got here. What to do about it, well, that's where we begin today. CBS News chief legal correspondent Jan Crawford and CBS News election law contributor David Becker join me now at the desk. Jan and David, you were both there. Jan, you have 30 years of covering the Supreme Court. This is a highly unusual, deeply historic day among many in the court's history. Your impressions?
Well, I mean, I thought what was most striking is how after those 2 hours of extraordinary arguments, and you outlined it all, the stakes so clearly, how they seem to be, unlike in typically explosive, divisive, contentious cases, how they seem to be searching for consensus. They seem to be trying to find some common ground because they saw problems with the why, with the if we go this way. They saw real problems with allowing a state to say we can kick a candidate for president off a presidential election ballot. So to me, just watching them as this argument progressed, seeing conservatives and liberals kind of asking the same questions, referring back to the other question, to suggest that states do not have this ability under Section 3 of the 14th Amendment, as you put it, a question never asked before because it's never been tried before. We've never had a former president like Donald Trump before, to suggest that states simply don't have this right. And of course, they played out the impact of it. What if they did allow it? You saw the Chief Justice of the United States saying, I could see a scenario where Republican states would try to kick a Democrat off the ballot, but the Pandora's box would be thrown wide open.
To that point about the practical application of if the Supreme Court did validate the Colorado Supreme Court, let's play Justice Elena Kagan offering some thoughts about that during the oral arguments. Let's run that.
I think that the question that you have to confront is why a single state should decide who gets to be president of the United States. You know, if you weren't from Colorado and you were from Wisconsin or you were from Michigan, and it really, you know, what the Michigan Secretary of State did is going to make the difference between, you know, whether candidate A is elected or candidate B is elected. I mean, that seems quite extraordinary, doesn't it?
No, Your Honor, because ultimately it's this court that's going to decide that question of federal constitutional eligibility and settle the issue for the nation.
That's Jason Murray, the attorney representing Colorado, talking to Justice Kagan. David, it wasn't Alito who brought that up. It wasn't Clarence Thomas who brought the practical applications of this. It was Elena Kagan.
Yeah, and you could clearly see, Jan's exactly right. In Supreme Court arguments, you often have this, through questioning, a conversation occurring between the justices, but it's really hard to tell how those justices might come out at the end. This was not that kind of case. This was unusual. I mean, you had a situation where you could clearly see the justices trying to find ways to shape this argument, and this issue of potential chaos from different state rulings or one state basically forcing all the others down a certain path was something that repeatedly came up in this. And this is why they ultimately, as you know, they didn't answer the why, but they were trying to get to the how and when do these issues come up. And it clearly was troubling for them that this could be a state court issue decided 50 different ways.
And David, you engage on a regular basis with election officials, Secretary of States, and county election officials. Describe for the audience how they are looking for clarity on this question.
Yeah, almost unanimously, they don't really have a strong opinion one way or the other on whether he should be disqualified or not. They might have some emotional feelings about it, but it's not really part of their jobs. They want this to be resolved and resolved finally on the merits as quickly as possible. The primary ballots in pretty much every state have already gone to the printer. They have Donald Trump's name on them, even in Colorado and in Maine. But the issue of whether or not Donald Trump, if he is the nominee of the Republican Party, is qualified to serve as president, and thereby is he also qualified to appear on the ballot in November, is a really important decision that needs to be resolved well before the summer, not just for those election officials. They need to know how to plan for the election, but for the American people, and honestly for the Republican Party, who needs to know whether or not they have a qualified candidate.
Jen, you mentioned this, and I want to play for the audience. Chief Justice John Roberts talking about a potential tit-for-tat scenario where red states do one thing, blue states do another. Let's listen to that.
I would expect that a goodly number of states will say, whoever the Democratic candidate is, you're off the ballot, and others, for the Republican candidate, you're off the ballot. And it'll come down to just a handful of states that are going to decide the presidential election. That's a pretty daunting consequence.
Now, whether you or anyone agrees that that would be the natural state of affairs, I don't know if that would be the state of affairs, but it's a hypothetical the Chief Justice entertained.
Well, and the lawyer pushed back on it, said, well, you know, just because these are frivolous arguments. And the Chief Justice went right back at him and said, listen, wait a minute. You may think those are frivolous arguments, insurrection, that's not insurrection, but there are people who will make them. And I thought what was so interesting after that is how Justice Alito jumped in and talked about the very specific example of impeachment. Another issue where, you know, we didn't have an impeachment for 100 years after President Jackson. Bill Clinton is impeached, and since then we've had 3. So once you start down, like once you open that box, we can't assume
Andrew Johnson
that
impeached
this is the one-off.
long period of time before Bill Clinton.
Yes.
But the significance of the Chief Justice bringing that up and your role, do you think, Jan, in the next week or two as this opinion comes together?
Well, I mean, I think they're going to do it. This has been fast-tracked. This is a special argument during what should be their winter recess. They know the time constraints here. They know Super Tuesday. As David pointed out, ballots have been printed or being printed. Super Tuesday is less than a month away. They'll do this quickly. And, you know, will
and
it
the
be
Chief
within
Justice will look for consensus.
He's going to want consensus. I think that actually, though, what we saw in this argument was that they all want consensus. I think the court really recognizes this is a moment for them to show they are above politics. The court has really taken a hit. Look at the polls. I mean, they're almost right down there with, you know, the media. No, a little higher than that. They're still higher than Congress. But, you know, it's really taken a hit. And if you look back to Bush versus Gore, which I covered, that was a case that was not a good moment for the court. It was not the court's finest hour. 5-4, the conservatives giving the presidency to George W. Bush, the liberals siding with Al Gore. This is an opportunity for the court to come together, and we'll see if the Chief Justice can do it. But I thought today what was most striking about that argument was how they did appear to be on a divisive issue involving a divisive person trying to find common ground.
And David, of course, Bush v. Gore was about a question that was legitimately discussable within a court of law. What was voter intent? Did ballot design and other methods create confusion about genuine voter intent? This is different. This is about past behavior disqualifying you from a future ballot.
Right. That was a really well-litigated case on both sides about a statewide election decided by 537 votes. Really close election. But this is a different situation. We're ahead of the election. We're deciding on qualifications. Can this person run for and serve as president? And I think one of the challenges, while the court might be finding consensus and that they might be helping the institutional credibility of the Supreme Court, perhaps with something even like a unanimous verdict here, this in some ways could very well still kick the can down the road for a political problem, especially on January 6th. If
January 6, 2025.
2025. So if, for instance, the Supreme Court rules, as I think Jan and I think they both are likely to rule, that the states cannot independently, without congressional authorization, disqualify a federal candidate or the president from their ballot, then what happens if Donald Trump wins in November? And he has all the electoral votes to win, but on January 6th, Democrats in Congress challenge those and say he's not qualified, not because he was the states didn't have the power, but because he actually engaged in insurrection. That would be a political argument and could create chaos all over again. So there's a potential here for kicking the can down the road that could be problematic.
And then, once again, whether the country wants to or not, it may have to confront what is the actual applicable definition of an insurrectionist. David Becker, Jan Crawford, thank you so very much. As we mentioned, special counsel's report on President Biden's handling of classified documents has been released. How the president is responding, that's next. You're streaming America Decides. Welcome back to America Decides. Special counsel Robert Hur finds no charges are warranted in his investigation into President Biden's handling of classified documents. But his report contains significant criticism of Mr. Biden. The inquiry was launched after sensitive documents, many marked classified, were found at the Penn Biden Center here in Washington and at the president's Delaware home. President Biden just responded to the report saying, quote, "The matter is now closed."
I was pleased to see they reached the conclusion I believed and knew all along they would, that there are no charges should be brought in this case.
Catherine Herridge and Weijia Jiang join us now. Catherine is CBS News senior investigative correspondent. She's outside the Justice Department. Weijia is CBS News senior White House correspondent, joining us, of course, from the North Lawn. Catherine, I want to begin with you. I want to read part of the report that I know you're familiar with. We can bring it up on a full screen. It said that Mr. Biden's conduct, quote, presented serious risks to national security, given the vulnerability of extraordinarily sensitive information to loss or compromise to America's adversaries. But addressing those risks when pursuing criminal charges, the only means available to this office, is not the proper remedy here. As I read that, Catherine, very bad behavior, but not chargeable criminally.
Well, Major, what special counsel Robert Hur concluded in this investigation is that President Biden willfully retained classified information, and some of this information was at the highest, most sensitive levels. There are two buckets of classified information in this investigation. The first were records that were clearly marked classified, and for the most part, they had to do with military operations strategy in Afghanistan. The second was a series of personal notebooks that then Vice President Biden kept. He took notes at the president's daily brief. This is a highly classified briefing that's prepared by the top members of the U.S. intelligence community, as well as National Security Council meetings. And what the report says is that we are talking about intelligence that's not only top secret, but also SCI, that's sensitive compartmented information. That means that the intelligence has especially fragile sources and methods, like human spying, for example, overhead satellite imagery, that if it's disclosed is very, very difficult to replace. And what's striking to me when you look at the Trump indictment on the unlawful retention of classified information, you're talking about intelligence in both cases at the very highest levels.
And Catherine, does the word willful, which is in the report, erase any consideration that this was inadvertent or this was a staffing issue that the vice president or then Senator Biden was unaware of? Meaning this is something he did, and there is reason to believe it was intentional.
This is one of the striking things in the report, Major. The special counsel uses the term willfulness, but then he goes on to explain that he doesn't think the evidence would bring a case that would be successful in a prosecution. And he cites, as one example, that there's reasonable doubt that boxes containing classified papers were moved into Mr. Biden's residence or moved into the office with his full knowledge. So it could have been done with him in the dark. It also talks about the fact that there was willful cooperation by his team with the special counsel, in stark contrast with what they allege happened in the Trump case. And obviously what's getting the most attention right now is special counsel Hur's observation, I won't call it a conclusion, but observation, that during the interviews, President Biden had a very fractured memory of these records and his time in the vice presidency, and that these gaps would create reasonable doubt among some jurors.
I want to bring that issue that you just raised, Catherine, to Wee Jiang at the White House. Any reaction from the White House to some of the contentions, suggestions, observations in Special Counsel Robert Hur's report about the president's memory?
In the statement responding to the Hur report, the special counsel was very pleased, he said, that there were no charges found, and went on to say that this is what they assumed would happen all along because there was no wrongdoing in this matter. But Major, at the very end of the statement, he does write that we disagree with a number of inaccurate and inappropriate comments in the special counsel's report. Nonetheless, the most important decision the special counsel made, that no charges are warranted, is firmly based on the facts and evidence. And so they are saying some of the characterizations of President Biden and his memory are not rooted in facts, but rather are subjective. But, Major, these descriptions are very damaging to President Biden, potentially, especially given the context that there are already so many mounting questions about his age and his mental fitness. In this report, the special counsel writes as one example that that Mr. Biden would likely present himself to a jury, as he did during our interview of him, as a sympathetic, well-meaning elderly man with a poor memory. He goes on to list several examples of when Mr. Biden could not remember when he served as vice president, as another example, or when his son Beau died. And there are many of these. In fact, so many that the White House counsel sent a letter to her asking that you revisit and revise your descriptions of President Biden's memory in the report. Because, again, the environment with which this is coming out is really important, Major. And the Trump campaign is going to seize on these descriptions about the president's mental fitness and sharpness as they, build their case against the president to come back to the White House.
And Weija, in about a minute or so we have left, this interview with the special counsel occurred around October 7th, when Israel was attacked by Hamas, and that, as the White House has underscored, was a rather tense and distracted time for the president.
President Biden himself addressed this, Major. He said that he was dealing with an international crisis when he decided to sit for 2 full days of interviews with the special counsel because he felt it was so important. So we know that Hamas attacked Israel on October 7th. These interviews took place on the 8th and the 9th. It's something that he felt the need to point out, both during a speech that he gave on a different topic just a short time ago, as well as his paper statement. So he was using that to underscore how important he believes this investigation is, and again, reiterating the fact that he wanted to cooperate every step of the way.
At the White House for us, Wee Jiang, and at the Justice Department for us, Catherine Herridge. Thank you so very much. 26 delegates are up for grabs tonight in Nevada's Republican caucuses. Next, the latest on the race for the GOP nomination. You are streaming America Decides.
know why she continues, but let her continue. I think she hurts herself, but I think she hurts the party, and in a way hurts the country. In Nevada, she lost to no name. She had a no name, and she lost by, I guess, 40 points. So I don't know why she continues.
Welcome back to America Decides. That was former President Trump taking, as you heard, a swipe at Nikki Haley for finishing behind, quote, none of these candidates, unquote, in Nevada's primary earlier this week. Trump, who was not on the primary ballot, is expected to sweep tonight's Nevada caucuses, which offer all 26 delegates in the state. Robert Costa, Katrina Kaufman, and Ed O'Keefe join me now. Robert is CBS News Chief Elections and Campaigns Correspondent. Katrina is a CBS News campaign reporter and an attorney, importantly. Ed is CBS News' senior White House and political correspondent. Robert, Nevada calls itself the battle-born state, but there's really no battle in Nevada for the Republican nomination. The primary and the caucus were not contested in any effectual way by Nikki Haley, yet Trump wants to make a big deal out of what's going on there.
This is about former President Trump building momentum as he tries to secure the nomination. The real test for former Ambassador Haley will be the state she is also the former governor of, South Carolina, which takes place later this month.
Ed O'Keefe, would you be so kind as to explain why this is a double process in Nevada, a primary and a caucus?
Yes, well, we're on the Las Vegas Strip, Major, so we'll call it a double billing, if you will. Tuesday night was the state law mandated primary that Republicans held, but had determined they didn't want to use to actually award their delegates for the presidential nomination. The state judge ruled that parties can decide however they want. So the Trump-aligned, Trump-dominated state party opted instead to hold a caucus, which is what Nevada used to do, believing that he would have a better chance of running up the score and completely dominating the contest. So they're holding it this afternoon. And later tonight, just literally a mile from where I'm standing up at Treasure Island, the former president will address his supporters here off the Strip and declare victory in something that the Haley campaign and every other Republican who had been running had said was an already fixed contest and one not worth competing in. It's an example of how incredibly controlling the Trump campaign, Trump orbit is now, of key state parties in battlegrounds across the country, whether it's here in Nevada, whether it's what's going on in Arizona, what's happened in Michigan, in Florida. Trump allies seizing control of big state parties in critical states in order to control the primary process and hopefully then deliver a general election victory in those places. But there's been criticism that this was a confusing, costly, unnecessary double billing this week, and that the former president could have easily just won a primary if he'd competed in that one instead.
And to that point, Ed, is there much energy in and around Nevada Republican circles about this caucus?
Outside of his, most ardent supporters, not necessarily, no. This is a city and a state consumed by what's happening on Sunday, not on what's playing out tonight. That's understandable. But, given the foregone conclusion that it is, we'll see how high turnout is. Haley managed to get 14,000 votes, lost, of course, to none of the candidates' option by several more thousand. Let's see what the turnout is tonight in this caucus, in this basically Trump-only affair, and if that signals yet again in another early state whether turnout has been suppressed either due to a lack of interest or a lack of drama.
Ed made some reference to something happening on Sunday. I think that's an oblique reference to some kind of football game, maybe, there in Las Vegas. Katrina, quite separate from the political machinations there in Nevada, one of the things you observe for us on a routine basis is the various legal challenges around the former president. Today we had the 14th Amendment case before the Supreme Court. Earlier this week, we had a 3-judge panel say that the former president, does not enjoy absolute immunity. These and other legal issues still surround the former president.
Yes, it's been a big week. So President Trump was found to not have presidential immunity related to his D.C. election interference case. And then just a couple days later, we're here at the Supreme Court weighing whether or not he can be disqualified from the ballot in Colorado. And the overall read from today is really that there are at least 8 justices who are leaning towards siding with Trump with this, really that there's a national federal overriding interest that one single state can't determine whether or not Trump remains on the ballot. And that was a big takeaway. Another interesting thing today is that they barely addressed this question of whether or not Trump engaged in insurrection, whether an insurrection took place on January 6th. There was very little discussion of that, which is another core part of Section 3 of the 14th Amendment, which is the aspect of the Constitution that was at issue in these arguments.
Thank you very much, Katrina. Robert, you mentioned South Carolina. Nikki Haley is engaging there. She's also raising money in Florida, Texas, California. Is what you've seen in the 2 weeks or so since the New Hampshire primary indicative of a campaign that has any chance in South Carolina and at the same time trying to scale up to a national campaign or something that looks like a national campaign for Super Tuesday on March 5th?
It's hard to see how she gets out before Super Tuesday, even if she is beaten in South Carolina by a pretty sound margin by former President Trump. Talking to her allies, they believe she can make some sort of political statement on Super Tuesday. For example, Massachusetts, a state close to New Hampshire, where she did relatively well in terms of winning over independents, some anti-Trump voters, people looking for a new generation. If she could pick off some of these states, as you look at the map there, like Massachusetts, perhaps some of those other New England states, maybe some like Colorado or Utah in particular, where Senator Mitt Romney and many Republicans there are not fans of former President Trump, then not only would she make a case that she should still be in the race as an alternative to former President Trump as he faces all of these legal challenges, but she's also making a case potentially for 2028. You think about past campaigns, staying in and accruing delegates is also a process of accruing political capital and stature in the party. And as long as she has the money to stay in, I expect her to stay in based on my conversations with her orbit.
And O'Keefe, back to you in Las Vegas. You spend a good deal of time focusing on the president's reelection campaign as a White House correspondent for us. Give me your sense of what today will be thought about within the confines of the Biden reelect campaign. On the one hand, you see the Supreme Court appearing to move toward siding with the former president on the 14th Amendment. And then you also have Robert Hur's report that does not bring criminal charges, but has some very stinging language in it about the president's conduct as vice president and senator, and some observations the White House most definitely takes issue with about the president's memory.
That was for me, Major, right?
Yes.
Just making sure.
Yes, indeed.
Yeah. So, look, I think today, more than any other so far, really encapsulates the vulnerabilities that both of these leading contenders have, the concerns that voters have over either of them being the nominee and then ultimately serving as president. The fact that the former president, once again, before the Supreme Court now, fresh concerns or reminders of the concerns of past and perceived current and future threats to American democracy. The Biden campaign will continue to seize on it, believes it's one of the bedrock reasons why he cannot be president again. But this special counsel report coming today, while the president is legally cleared, as it always appeared he probably would be, politically it remains a real mess. And now, in writing, you have nonpartisan federal prosecutors raising concerns about his age, about his faculties, about his ability to recall some basic things about his life and his career and his family. It's catnip for his Republican opponents. I note the House Republican statement tonight raising concerns that if he cannot recall these kinds of details, then he's unfit to serve in the Oval Office, and that's an argument Republicans will continue to make. His team pushed back on it, saying it was inappropriate for the special counsel to go there, but he did, and it will be seized upon and used against him in the court of public opinion between now and November. And the argument, Major, will be you either cooperate with prosecutors or you cause conflict for them. Which one, voters, would you prefer? We'll get an answer in November.
Thank you, Ed, in Las Vegas. Katrina, I want to go back to you outside the Supreme Court ever so briefly. There are other legal issues still pending for the former president, not related to the 14th Amendment or absolute immunity, correct?
Correct. There's still the Florida classified documents case. There's Fulton County, although that's currently embroiled in a bit of a scandal. And we may have the Manhattan hush money case coming up as well. And I mean, related to the immunity, I also want to point out that Trump has until Monday to appeal to the Supreme Court in that case. So it's possible that he could be back here to talk about that very soon as well.
Katrina Kaufman, Robert Costa, and Ed O'Keefe, thank you all very, very much. What are the questions before the Supreme Court in the Trump ballot eligibility case? We will talk to two law professors about the most important ones when we come back. You're streaming America Decides. Welcome back to America Decides. The Supreme Court heard arguments today over whether or not former President Trump is eligible to be on the primary ballot in Colorado. Colorado's Supreme Court kicked him off the ballot, at least temporarily, citing the so-called insurrection clause of the 14th Amendment. It's Section 3 of the 14th Amendment, which says in part, no person shall hold any office who, having previously taken an oath to support the Constitution, shall have engaged in insurrection, unquote. Derek Muller is a professor of law at Notre Dame Law School, and Lawrence Lessig is a professor at Harvard Law School. Both join me now. Professors, I'm indebted to you both for being with us. I want to start with you, Professor Muller, and then go to you, Professor Lessig. If you were to summarize for a law school class in 40 seconds or less the most important component of today's oral arguments, Professor Muller, what would you say?
I'd say the Supreme Court was skeptical that one state could judge the qualifications of a candidate like this in a way that could affect all 50 states. The court seemed very skeptical that one trial court in Colorado could make this decision under Colorado rules of evidence, and that we might have inconsistent verdicts around the country, and that we might ask the Supreme Court to step in and clean up this mess if there are inconsistent verdicts. So the court was very concerned about one state affecting the national interest, and also about asking the Supreme Court to have to step in and resolve these disputes in the future.
Professor Lessig, your summary for your class.
Yeah, I would agree with that. I would also emphasize that the court was keen to see Congress play a role in specifying the procedures by which this issue could be adjudicated. I think the court recognized how complicated it was, and it pointed back to the historical times when Congress actually provided a remedy under the 1870 Enforcement Act that would enable you to remove somebody because they've been found to be an insurrectionist. And I think that's an appropriate place for the procedures to be set, and there's no such procedures that could be invoked here because President Trump has not been criminally prosecuted for insurrection.
And Professor Lessig, I know this is something that you have paid very close attention to, Congress's role in this, whether Congress has or hasn't involved itself in application of the 14th Amendment. Tease that out a little bit more for our audience, if you please, be so kind.
Well, we typically look at the Constitution and think it's obvious that a court can just invoke the Constitution and enforce it, which is why Colorado thought it was obvious that it could just invoke the Constitution to enforce it against President Trump. But the 14th Amendment is a complicated amendment. And some of the provisions, like Section 3, the provision at issue here, and Section 2, which is about apportionment if male voters are denied the right to vote, are very complicated to figure out how they might be enforced appropriately. And what the courts have done is say, in that kind of context, we're going to rely on Congress to take the lead or to set the framework before we're going to allow the provision to be enforced against particular people. And I think that makes sense in a context where there are so many questions about how you determine whether someone is engaged in insurrection, what kind of proof there is, what's the process. Those things should not be made up ad hoc by state courts or, frankly, any courts without the guidance from Congress.
Professor Muller, it was the consensus after the oral arguments concluded that the justices did not appear much interested in deciding or burrowing into the question of whether or not the former president engaged in or incited an insurrection. Did that in any way surprise you?
It wasn't that surprising in the sense that I think the Supreme Court wants to stay as far away from politics as possible and stay as far away from some of these contested factual issues as possible. So questions about whether or not Trump engaged in insurrection, getting at his state of mind on January 6th, getting at the meaning of his tweets, interpreting the content of his speech at the ellipse, that was something I think the court wanted to stay as far away from as possible. And given how many complex legal issues are at stake in this case, and how many different directions that it could go. I don't think it's a surprise that the court chose not to spend much time on January 6th itself and spend much more time on text, history, and law.
Professor Lessig, I have read some of the amicus briefs, meaning friend of the court briefs, supporting what Colorado did. And one of the takeaways I have from those briefs is it's plainly evident that there was an attempt by the former president to block the peaceful transfer of power. By any common understanding, that is insurrectionist-like behavior. It is an assault on the form of government of our country. And therefore, this should be an open and shut case. Clearly, that's not what the court thought. What are your reactions to those who make that kind of argument?
Look, I completely agree that the behavior on January 6th was outrageous. And I think it's a sufficient reason to say he should not be president again. But whether it translates into a legal remedy to kick him off the ballot is a more complicated question. And I think the appropriate view, which I think the court affirmed, looking at early jurisprudence that set the pattern of congressional responsibility here, suggests that if you're going to use the courts to kick people off, it's going to be through the structure of a statutory remedy that's been set by Congress. And Congress, for reasons that nobody seemed to know, dropped the most important remedy in the 1940s. So we basically only have a criminal remedy, and that wasn't used in this case. And so that means that as outrageous as his behavior was, and it clearly was, the real question is whether the law gives people the ability to kick him off the ballot. And as the law stands now, without criminally prosecuting him, the answer is no.
Professor Mueller, if you engage in any basic civics lesson about the Constitution, you are familiarized with Article 2. And that was made reference to by the attorney representing Colorado, that it is Colorado exercising its Article 2 rights, time, manner, and place to supervise elections and eligibility. This is an eligibility question, clearly within the purview of Colorado, and it was exercising its rights in that regard. What's your answer to that particular contention?
Yeah, I think the court agreed that the state can set some rules for elections. The state can determine who's on the ballot. We know that not all the same candidates appear on the ballot in every state. The Green Party or the Libertarian Party might not be on the ballot in every state. But the court bristled here at the fact that Section 3 seems different, and especially when it's contested qualifications. In other places, if you're dealing with a 21-year-old or a Nicaraguan national, those are candidates who are ineligible to serve as president, keeping them off. But the court kept circling around this notion that there's something about Section 3 of the 14th Amendment that requires Congress to provide the enforcement authority. And so while it's true that Article 2 gives states a lot of power to come up with a manner of appointing presidential electors, to develop the ballot and include candidates, and maybe even keep certain candidates off, Section 3 feels different in kind, and it feels different in the sense that there are these contested factual disputes, and one state shouldn't be the one to make that decision for the rest of the country without Congress stepping in to provide some guidance about how they do that.
Coming to us from two of the finest law schools in our country, Professor Derek Mueller, Notre Dame Law School, Professor Lawrence Lessig, Harvard Law School. I'm indebted to you both. Thank you so much. A $96 billion foreign aid package is making its way somewhat haltingly through the Senate. We will get an update from Capitol Hill. That's next for Streaming America Decides. Welcome back to America Decides. The Senate, in something of a reversal, has voted to advance a $95 billion foreign aid package that would provide military and economic assistance to Ukraine, Israel, and Taiwan. CBS News congressional correspondent Scott McFarland joins me now. Scott, this is a multi-episodic saga. We are on probably episode 12 or 14. I've lost count. Catch our audience up on the current state of play and whether or not, with the package as it's currently defined, there is some remote chance of putting a debate about immigration policy back into it.
Oh, Major, I'm loath to use sports analogies, but this really begs for a baseball one. No runs have been scored, and we are back at this top of the lineup and try this again. Okay. Here's the latest state of play. The Senate's going to try to move forward. A test vote did so today with this plan to spend tens of billions of dollars to help Ukraine and help Israel without the border restrictions and the border legislation that was discussed over the past couple of months. That's where we were months ago, when congressional leaders were trying to push through an emergency plan requested by the Biden administration to help Ukraine and help Israel without getting into the nettlesome issue of border security with the unrelated issue of border security. 2 months of pretty fraught negotiations, and 72 hours after the bill is posted, it's dead, and they're moving to this other plan. It's going to take some time. The Senate's going to need the senatorial procedures to work their way through. They'll be here through the weekend. They'll have a rockin' Super Bowl party on the Senate floor. And then as early as next week, they can try to advance this thing, help pay for Ukraine, help pay for Israel. But because the baseball analogy still fits, Major, at the top of the lineup, they have that same problem. The U.S. House wants nothing to do with this, and its future is uncertain.
So is it possible, Scott, that as the Senate considers this larger foreign aid allocation of funds, it could revisit the immigration component and say the things that were negotiated are insufficient and we want to either amend that or rewrite some components of that? Or do you think, based on what you're hearing now, that immigration is still going to be kept to the side, nettlesome as always, and not ultimately part of whatever the Senate decides to pass?
I think it's quite clear there's going to be some debate, some discussion of immigration issues. Some of the amendments, if not many of the amendments, are going to touch on some of the issues the border security proposal touched on. But it doesn't really change the calculus here. If the proposal that was put forward Sunday night by one of the most conservative members of the Senate, James Lankford, with the support of the Senate Republican leader Mitch McConnell, did not carry the day with the Republican Party or anybody in the U.S. House, little versions of it added to this bill to fund Ukraine and Israel certainly won't either. And the kernel here remains the same. There are dozens, if not a majority, of Republicans in the U.S. House who simply do not support funding Ukraine in any context in any way. Nothing has changed. And some of the support for Ukrainian aid may have loosened or weakened a bit here in the Senate. We are back at the start of the lineup, and nobody's scoring any runs.
Very good. Scott, with about 90 seconds to go, any reaction on Capitol Hill to Special Counsel Robert Hur's report, including its reference not only to President Biden's age and memory issues, but also the decision not to pursue any criminal charges?
Yeah, a better question might be, has anybody not responded on Capitol Hill in the couple of hours since the report was issued? All of it predictably down party lines. Top Democrat on the House Intelligence Committee says it is absurd to compare what Special Counsel Hur's report said about President Biden and what Special Counsel Jack Smith is prosecuting with Donald Trump. The Democrats reinforcing the fact that there was no obstruction. President Biden answered every question, opened all the doors, let the investigators in. Donald Trump's charged with felony obstruction and conspiracy. Republicans really leaning into the references in this 345-page report, which raise questions about President Biden's memory, his faculties. They've made that a big part of their response, not so much a legal response as a political one, that if he's not fit to be prosecuted because of possible memory failures, he's not fit to hold high office. Oh, I expect that to be a critical part of their campaign messaging moving forward.
Scott McFarland coming to us on Capitol Hill with the update not only on legislative activities, but reaction to Special Counsel Hur's report. Thank you so very much. Well, that does it for today. We will be back with another edition of America Decides Monday at 5 p.m. Eastern. You'll want to stay tuned for that. In the meantime, here's something you already know. Quick reminder, you're streaming CBS News.